Ladies and gentlemen, my name is Daniel Fruz, and I'm the founder of the Westside Bar Association, and it is nice to see so many excited faces in the audience. We are exceptionally excited tonight because the event that we're going to put on here and the quality of event that we're going to put on here, in my opinion, is second to none. Before we go into that, I just want to say some general things about the WBA, some administrative stuff that if you've been to any of our previous events, you've probably heard me say this before. Can I just get a show of hands? How many people are in the WBA Facebook group? All right. It's a decent. We'll get that number up next time. No worries. So why join the WBA Facebook group? Very simple. A, it's free. B, let's not kid ourselves. We're all already addicted to Facebook, so it's very nice to have a bar association accessible via Facebook. And here's the beautiful thing, ladies and gentlemen. If you're looking for a job, if you're looking for case referrals, or hey, maybe you have a question about the CCP, civil procedure, criminal procedure, federal procedure, whatever it might be, people actually post questions in the WBA Facebook group, and they get answered, again, for free. The other beautiful part about the Facebook group is that you are the first to know about any updates, any events that we're throwing, and I'll tell you one other thing that we do sometimes. When we are coming up with our next events, we'll actually put up a poll in the WBA Facebook group, and you guys get to vote. You guys get to vote on who's going to be here, you guys get to vote on the next events, and I promise you, no one else is doing that. So when you get home tonight or tomorrow, take a look at the WBA Facebook group and join. If you're old school and you prefer email, you can just go to our website and sign up for our listserv there. We won't spam you. We'll only tell you about upcoming events. So thank you all so much for being here. I want to be very brief. I want to give the microphone over to Mr. Lou Shapiro, who put this panel together, and we want to get the party started. I hope you guys are ready.
I'm also stalling for time so the rest of the people at the cash bar can get in here. Welcome. You're not here to hear from me, so I'll be very quick. Just a few recognitions. First of all, I want to thank the Westside Bar Association Board. They helped put this together. It was not just me. This was a team effort. Thank you to the volunteers who are helping tonight with the seating in the back. We appreciate that. We have a star panel here this evening, right? As we have, and I'll just start from the far left, we have, if she may rise, Lena Nguyen, a 4-time Emmy Award winner, newscaster from Channel 9, really upgrading our image. We appreciate that, Lena. Thank you for being here tonight. We also have co-moderating with Lena will be Dan Fruz, the president of the Westside Bar, you just heard, so he'll be helping out. And then we have Rena Durant, Deputy District Attorney in Department 30. That's right. Professor Pavel Wansowitz, UCLA Law. Thank you for being here tonight. And now I'm going to need, that was perfect time. You can have I'm probably going to mispronounce the name anyways, but, right. Dr. Ruby Javed Ghaffar, LA County Coroner's Office, who is accompanied by Dr. Ode Ukpo. And yes, the owl is here, but it's in the back to make sure you come back and stay until the end. Parking validation. I recommend if you get a drink downstairs at the bar, it's like half price on the valet. So I'm not encouraging drinking and driving. It could be a seltzer even. So just know about that. Finally, a few more acknowledgments. We have some really relevant, newsworthy people that are part of Los Angeles. We have to recognize them tonight. We have Gigi Gracieta here from Fox. If you could please stand, a reporter for many years. You would recognize her. We have Shannon Farron from the Gary and Shannon Show on KFI. She's in all blue. Please stand. Where are you? Where are you hiding? She doesn't want to. She already got her picture, so she left. Right? We have Frank Motek from KNX 1070 here tonight. You'll hear him on your way home talking about the event. Thanks for being here. And finally, Mary Beth McDade, who is covering the event for KTLA, so you probably will all see yourselves on television tonight. So you're going to all clap for yourselves. The Staircase. Why are we here tonight? You know, you watch an episode or two, and it does play on you. You start thinking, did he do it? Didn't he do it? I'm not sure. It takes you through this roller coaster ride. But like in any production, there's always a hero. And I think we all would agree in this room that the hero is not necessarily Michael Peterson, the defendant in the case, who's walking as a free man today. And the hero is also not the Durham County District Attorney's Office, who originally got a conviction. The hero of this story and that show is sitting to my right, and that is David Rudolph. That's the hero. David, you've inspired us, and we're just so happy on your world tour. We are your one stop here. Please continue to inspire us, and we hope for a Staircase Season 2. David Rudolph.
Thanks, Lou. And thank all of you for coming. This is an amazing turnout here, and I really appreciate it. How many folks in the audience are public defenders? All right. I started as a public defender in the South Bronx too many years ago to reveal, and then I went to the Federal Defender Office in Brooklyn. How many of you are private criminal defense lawyers? All right. And I take it the rest of you are still lawyers, but you don't do anything interesting. Is that right? All right. So, you know, Lou asked me to start off tonight to just sort of get things rolling, and it seemed to me that probably what most lawyers are interested in is, why did I agree to do this? And how did I protect attorney-client privilege? And why would I allow my client to be filmed in all these situations? And so I thought it might be useful, since the answers to those questions don't appear in the Staircase, to talk some about that, just to start off this evening, and sort of give you all a little bit of inside baseball about how that all came to be. So the story actually starts with another trial that I did. It was the Ray Caruth trial. Ray Caruth was a North Carolina Panther football player who in 1999 was charged with capital murder arising out of the shooting death of his pregnant girlfriend, Sharika Adams. And that case got an enormous amount of publicity because Ray was an active NFL player. He had actually been the leading first-year receiver in the NFL the year before. He was a rising star. And he was charged with capital murder. I mean, he went from the practice field to the prison, to the jail. And so that got enormous press. And I was fortunate enough to represent Ray, represented him for 3 months. He was charged with murder. It was allegedly a murder for hire. He was charged with conspiracy and various other lesser offenses. And after 3 months, the jury acquitted him of the murder, but in a verdict that I'm not quite sure I understand, convicted him of conspiracy to commit murder. And the benefit of that for Ray, obviously, was that instead of facing the death penalty, he got sentenced to 18 to 24 years in prison for the conspiracy, and he actually is getting out in about 2 weeks. And I won't get into the details of that case, but as a result of that case, that was covered by Court TV, which used to exist. Some of you may remember that. And it got nationwide coverage. And at the same time that that was going on, there was a little notice case in Florida, in Jacksonville, Florida. And there was this small team of French documentary filmmakers who had found this case. The defendant was represented by a public defender, and they covered the case, and they made a documentary about the defense of this case. It was a murder case. It was a poor black defendant charged with murdering a white visitor to Florida. And the public defender got an acquittal despite a confession and an eyewitness identification. And the filmmakers made a film called Murder on a Sunday Morning, which if you haven't seen, you should see. It won the Academy Award for Best Documentary in 2002, I believe. So they were finishing that up about the time that I was finishing up the Carruth case, and they were searching for another project. And I know there's been a lot of talk on the internet and Twitter and all these things about Reddit, about how Michael hired these people. Nothing could be further from the truth. The French film company, the documentarians, reached out to various stringers, and one of the persons they reached out to was a woman by the name of Mary Beth Stevenson, I think was her name. I think she was based out here in LA and was covering things for Court TV. And she just suggested that they call me to see if I had anything going on. And as luck would have it, about a month or two earlier, I had started representing Michael Peterson in this case. So they contacted me, and I wasn't terribly eager to do this, to be honest. You know, I never let my clients talk to the media before trial. We had turned down all kinds of interviews with 2020 and, you know, all those sorts of news shows. And, you know, when they approached us, it was not about an immediate interview. It was about a documentary, which is a little bit different. So we agreed to meet with them, Michael and I and my investigator. And Michael became very enamored of the idea of having this Academy Award-winning French film crew filming the entire thing in Durham, and not because of any vanity, because he was convinced that he would not get a fair trial in Durham. He had spent a lot of time writing columns for the local newspaper, and the columns attacked the local police, and the columns attacked the local DA, and the columns attacked the local government, and they all hated him. I mean, they weren't gentle columns. They were very acerbic, sharp columns. And so he was convinced that as a result of that, they were going to be out to get him. And he just thought having this Academy Award-winning film crew there would deter some of that, you know, that it might keep the playing field a little bit more level. And I couldn't argue with that. I understood it. But I didn't really think that it was going to be all that unfair. I knew the judge. I had known the judge for years. I had tried cases in Durham. And Durham was certainly not the most conservative place in North Carolina by a long shot. So I wasn't convinced that we needed that to level any playing field. And I was also very concerned about the attorney-client privilege, obviously. And so when I met with the filmmakers, Michael sort of agreed right away that he was willing to do it. And I was, you know, I said, well, hold on, you know, we need to talk some more. And I told them that I'd be willing to do it, and I'll tell you in a minute why I was willing to do it. But I told them that there were going to be certain conditions before I agreed to do it. One condition was that they would agree that at least before the trial, anything they filmed before the trial, was being done to document it for my purposes. So that in essence, when they were filming me meeting with Michael or an expert, they were doing that as my agent, if you will. I wasn't controlling what they filmed, but I wanted them to be covered by the attorney-client privilege to the extent I could create that, that protection. So that was condition number one. Condition number two was that they would have to send the footage that they took every day that they were filming back to France that night. And the reason for that was that I was worried that the DA would try to subpoena it, and I wanted him to have to go speak French in order to get the film. And indeed, as it turned out, there was one witness who we interviewed, and the film crew filmed it. And at some point, the DA reached out to the judge and said that he wanted to try to subpoena that. And the judge called me, and you know, I called the filmmakers, and they called the judge and explained to the judge that the film that the DA wanted was actually in Paris. And you know, they weren't quite sure how the DA was going to get that, but if he wanted to get it, then he was going to need to fly over there and make his argument. So that was condition number two. Condition number three was that they would not show any footage publicly until all appeals and all trials and appeals had been exhausted. So that was condition number three. And condition number four, and I'm not sure any American film crew would have agreed. I'm sure the TV people, the journalists in the room are shaking their heads already about how I got this agreement. But it went even further than that because they also agreed that before they filmed it, before they showed anything, I would be permitted to see it. And if I had any concerns about whether what was in the film might prejudice Michael in a subsequent trial, assuming we had lost, that they would agree to discuss that with me and take my views into consideration in deciding whether to keep that particular scene in the final episodes. And as I said, no American film crew would ever agree to those conditions. So this film, I don't think, is ever going to be made again. I don't think you're ever going to see, at least I hope you don't, without those conditions being met, another lawyer agreeing to allow what I allowed because it needed to be really tightly protected from any kind of disclosure. And as I said, I don't think any American documentary filmmaker would ever agree to those conditions. But it was really simple for me. It was sort of like, okay, if you don't want to agree, that's fine. You won't film. You know, I mean, that's your choice. If you want to film, these are the conditions. I'm not going to be unreasonable. You know, this is going to have to be a matter of trust, and to some extent, I'm trusting you that you're not going to disclose this footage, you know, before the end of the trial and appeals, and you're going to have to trust me that I'm not going to be sitting there making unreasonable demands on you. Jean de Lestrade, who's the director and the producer, agreed to all that. And in fact, when the first 8 episodes came out, and they came out in, I guess, 2005. Back then, we didn't have streaming. I feel really old saying all these things that we didn't have. They came out on DVDs, you know, sold by Blockbuster, which made a really great decision not buying Netflix shortly thereafter. I spent literally 2 days. They flew me to Paris. I spent 2 days in a small office watching the first 8 episodes, which was probably the most depressing 2 days I've ever spent in my life. You know, the wounds were still pretty raw at that point. But I watched it, and I think you can probably tell that I didn't exercise any control over what went into the film, because you all see me losing it with the video operator in a scene that I was not terribly proud of at the time. And that remained in. I didn't ask them to take it out. I was tempted, but I didn't. And what you see in The Staircase is real-time video. There was no, hey, could you do that over again? There was no, you know, cut, you know, let's film that scene again. They didn't ask me to say or do anything that I wasn't planning on doing and saying. Now, they weren't there 24/7, so let me make that clear. So did they capture every conversation I had with Michael over the year and a half? No, of course not. They were living in Paris. Basically, what would happen is, if there was something important that was going to happen, and again, this is where the sort of the trust comes in, I would call them, or I guess I emailed them then. I wouldn't have texted them. And I'd say, hey, you know, the experts are coming to the house to help brainstorm about, you know, what the scene looks like. And then they would decide whether to come or not. So I tried to include them in the most important parts of it. You know, the brainstorming session that you saw, you know, the good facts, bad facts session, which went on, you know, for the better part of a day. You know, Josh Carton, his preparation of Michael for testifying. I mean, the things that I knew, the focus group. So the things that I knew were going to be important, they came to. And, you know, it was sort of risky for me, I guess. You know, I didn't know how I was going to come across. I didn't know for sure how all these things were going to appear in the cold light of day. But I had an agenda, so let me tell you what my agenda was. My agenda was to tear down the stereotypes that people have about criminal defense lawyers. You know, I've spent my entire career being a criminal defense lawyer. And, you know, aside from the questions about how can you represent those people, you know, which get really old really fast, you know, you watch Law and Order, and here's the defense lawyer, and he's all buddy-buddy with the prosecutor, and they're yucking it up about, you know, what they're going to do with the defendant. Or, you know, he goes in and he tells the defendant, you know, he can't defend him, the case is just terrible, he's got to plead out. Or he's drinking, you know, or he's lazy, or whatever. And the stereotypes, you know, I grew up, and I'm going to date myself again here, but I grew up watching Perry Mason. And Perry Mason was a hero, you know? I mean, when he represented somebody, a criminal defense lawyer, he was a hero, and he solved cases, and he sought the truth. And, you know, there's that, you know, you talk about a Perry Mason moment, which is the moment when the truth gets revealed. And that's what I grew up with. And that had been lost over the last couple of decades. And I just thought, you know, it would be really good for people, lawyers, non-lawyers, whoever, to be able to see how we do our jobs, how public defenders do their jobs, how private criminal defense lawyers do their jobs, how ethical, committed attorneys defend people every day in every community in this country. You know, what I did in that case It wasn't terribly extraordinary. I mean, it was just nice for me to be able to show everybody what the people in this room who are criminal defense lawyers or public defenders do on a daily basis. So that was my agenda, and I have to say that I am really, really, really happy about how this has all turned out. You know, I get questions every once in a while about, you know, would you do this again? You know, it took 15 years of your life, you know, all of that. And the answer is I would. And the reason for that is that I am getting tweets, which I never got before May. I now have 14,000 followers, which is bizarre to me. I'm not sure why they're following me, but they are. I get all these tweets and emails and messages on my web page about how, you know, I'm a conservative, or I'm a law and order person, you know, or, you know, I never thought that criminal defense lawyers did anything worthwhile. And I watched The Staircase, and it changed my view. And I've gotten scores, you know, I'm not sure if it's hundreds, but it's a lot of comments like that. And that's something that, you know, it's nice for me, you know, it's affirming and it strokes my ego and all that sort of stuff. But what's really nice is, to the extent that I have changed people's perceptions, not just of me, but of what we do, of the importance of our work, of the nobility of representing people who are at the worst moments of their lives, and, you know, sort of resisting abuses of power, and which certainly in this day and age is becoming more and more important. You know, to the extent I was able to send that message out to the general public, that's you know, a great legacy for me. That's just a really nice way to sort of ride off into the sunset at some point. So I appreciate you all coming here. Let me just give you a little bit of a preview. You know, I know that you all really want to see the owl, right? You all want to hear about the owl theory. All right. We've already... I'm going to start yelling at you just like the guy in the movie.
He's like, I'm not the owl.
Never mind. We don't need to do it. No, don't worry about it. We're not going to do the owl now. Sorry. No, we're not going to do it now. I've got a great clip. Can you cue up the clip, or is that going to be beyond? 30 seconds to a minute, real quick, switch it up. Yep. This is going to be worth 30-second wait. All right, I promise you. And I'm gonna keep my cool. I'm not going to get upset.
And the owl is here. It's just she's having her makeup done right now in the back. So I just bear with her.
All right, now before you start it, let me just cue up the story here. So, one of the things I really care about is the proliferation of junk science in the courtroom. You all saw Dwayne Deaver and what he did in the trial and what ended up happening. So I don't want to talk about that because you've all watched that already. But there's another expert, so-called expert, who testified in the trial who no one's ever seen before. His name was Sami Shabani. And Sami Shabani talked with a really crisp British accent, so he had to tell the truth. You can't lie with a British accent. And he claimed to have been educated at Oxford, of course. He claimed to be an expert in physics and mechanical engineering. And he also claimed to be on the faculty as a clinical professor of physics and engineering at Temple University in Philadelphia. And so, you know, we had this voir dire, and he was qualified because he testified about all these credentials. But I had done some research on him. It was last minute because we didn't have a lot of notice. And I turned up some stuff that was just a little bizarre about him. And so I ended up getting a hold of somebody at Temple, a lawyer friend of mine, and they sent me the faculty handbook, you know, and his name wasn't in there. And so I started digging a little bit more. And so the clip you're about to see is a portion of my cross-examination of Sami Shabani with regard to his methodology.
Now, you were also consulted with a case in Eagle Riverville, Wisconsin. Is that right? Answer, yes, ma'am. Question, that was a case where somebody was found dead with her head in a toilet bowl. Answer, that's what the husband claims, yes, ma'am. Now, in fact, in that case, the woman also had a significant amount of drugs on board, didn't she?
Which we believe the husband had administered to her, yes, sir.
I'm not asking you what you believed about the husband. I'm asking you whether or not the woman had a significant amount of drugs in her system.
Yes, sir.
Question, and you went there and you put actual heads in toilets. Is that right? Answer, as part of my scientific research, I found 3 volunteers, that word may be used loosely here, for 4 hours. I put their heads into the actual toilet bowl where the husband claims to have found his wife because science dictates that you compare apples with apples. The women volunteers were the same height and the same weight as the dead woman, and I wanted to see if it was physically possible for a woman of that height and that weight with that actual toilet to commit suicide by drowning or to drown accidentally. And the science says, no, you can't. Question, and the science was putting the heads in the toilet? Is that right? Answer, no, that was part of it. I asked these women, put your head in the toilet and see if you can drown yourself, and I'll try and fish you out before you succeed. But they never got close. They just simply couldn't do it. The laws of physics didn't allow them to drown themselves. Was that your testimony?
Yes, sir.
Is that what you consider to be even a part of science?
Of course.
You can't make this stuff up, right? The judge then struck his testimony and instructed the jury to disregard his direct. Sami then walked out of the courtroom. He was never prosecuted for his perjury. And indeed, a couple years later, as a result of that testimony and some other things that we had uncovered, there was a defendant in Wisconsin, I believe it was, who had been convicted based on Sami's expert testimony. And I contacted the lawyer in that case who was doing the post-conviction work, and that particular defendant, their conviction was overturned as well. So, no, thank you. So junk science is a real problem. You know, most of the people are a little bit more sophisticated than Sami was, but it's a real problem, and it's something I hope we can talk about. It's another thing that I think the owl theory is really important, and I understand why people are interested in it, but I really hope that tonight we can broaden the discussion, because the reason I'm here, the reason I'm going other places to talk, is not to bask in the glow of Netflix. And it's not to talk about whether Michael Peterson is innocent or guilty or whether the owl did it or didn't do it. It's really to talk about the criminal justice system, and not just to lawyers like you all, but to everyday people who will hopefully go out and serve on juries and be a little bit more skeptical of what they hear. So thank you very much for having me. I appreciate it.
So what I'm going to do, ladies and gentlemen, is Lena and I are going to moderate from the left so that the people who belong over here are the ones you get to see. Lena, what did you think?
Of what?
Well, what Mr. Rudolph had to say.
He actually answered a lot of the questions I had. When I first started watching the series from a media perspective, I was amazed at the access. Then I thought, what crazy lawyer would allow this? Then I thought, what crazy defendant would want this? And you answered those questions. And then my other question about that access is that I know having a camera there always changes the way people act. No one is ever 100% natural. I think it's just human nature that when you know you're being filmed, you just can't be 100% real. And I had a question of whether that affected how you did your job, knowing that it was being documented. But then you had so much control that you're right, you would never have those kind of restrictions held on any American film company, or for sure, no news company for sure. But really amazing. Yeah, I really enjoyed that. Thank you.
Just don't charge us more for this.
All right. No, and I know that no American news organization would ever do that. I think there's a question about whether that is really the right decision. You know, I leave that to all your ethical, expertise. But, you know, they wouldn't have gotten all that stuff without it. And I think what they ended up with is an amazing, amazing documentary. So, you know, I don't know the right answer there. In terms of the effect of the camera, you know, I mean, I've got cameras out there, and I don't think it really impacts me, you know, at least at this point in my life or career. I think, you know, when you're younger, it might. But I'm focused on doing my job. You know, if it's speaking to everybody, I'm focused on that. I'm thinking about what I'm going to say. I'm not looking at the camera. If I'm meeting with my client, I'm focused on that. And the film crew was really very respectful about that. So they would set up in a corner, and they'd have a boom mic, but, you know, it wouldn't be down in my face. It would be up above, so I couldn't really see it. They never interrupted. They never said anything. And I think at first it was a little awkward, you know, for my client and for the experts and whatnot. But what you see in that film, I don't think you see people feeling terribly awkward. You know, I think you see people pretty much acting the way they act. You know, whether it was Michael or the kids or his brother or me or the experts or whoever. So I hear what you're saying. I think, you know, if someone is not used to being on camera, it's a bigger problem. You know, I think for witnesses, you know, if there's cameras in the courtroom, I think that can affect them. But I don't really think it affected in any substantive way. Well, I'll take it back. There was one moment in the film where Judge Hudson refuses to rule on whether or not he's going to allow in the Germany and the gay stuff. And it was like a week before trial. And here I am, you know, I need to figure out, am I going to select a jury? You know, am I going to do voir dire on those issues? Am I going to open on those issues? And he's just leaving me hanging there. And I was about as angry as I could be. But I look at the film and it's like, wow, I'm pretty cool. You know, I just sort of close my pad and I walk away, and, you know, That wasn't how I was feeling. So I wondered afterwards, maybe I controlled myself a little bit more because there was a camera on. But other than that, I'm not sure it really impacted me.
Well, I think you succeeded because you've totally changed my view of defense attorneys.
Oh, well, thank you,
sir.
Thank you.
Fantastic. Fantastic. Well, ladies and gentlemen, one of the things we've done with this panel is we don't just have attorneys. We actually have doctors here. And we have doctors who are going to give their insight into this, and I think that's so critical with a case like this, with the ambiguities, to have essentially scientists here and discuss it. And we have two doctors from the Los Angeles Coroner's Office that are taking time out of their schedules to come here today and discuss the case with us. We have Dr. Ruby Javed Ghaffar. Please raise your hand so everyone knows who you are. And Dr. Ghaffar, what is your exact job title?
So I am the chief of the Forensic Science Laboratories Division for the Los Angeles County Department of Medical Examiner Coroner. So I oversee 6 laboratories for the Medical Examiner Coroner's Office.
Ooh, that's fancy. And we also have Dr. Ode Ukpo. Could you raise your hand so everyone knows who you are, sir? And please let us know your job title.
My job title is I'm Senior Deputy Medical Examiner at the Los Angeles County Medical Examiner Coroner's Office. And what that means is I'm one of the senior physicians there who conducts autopsies but is also involved in supervising other physicians.
Fantastic. So I just want to go ahead and open this up to the both of you. What do you think? What do you think about what Mr. Rudolph said? What do you think about the documentary? What do you think about the coroner's report? Let us know what you think.
Well, one, I just want to say I love how Lou placed us right after Mr. Rudolph discussed junk science. I'm actually a scientist, and just so you know the difference, I am a trained forensic toxicologist. I do not have my MD. I have my PhD in pharmacology and toxicology. So I did extensive research in understanding morphine tolerance and physical dependence, and for those that you know about opiates, it's used for pain treatment for cancer patients and spinal cord injury patients. So I've been in this field for over 15 years, so this is not my first rodeo. I've been in both the private and the public sector, so I've seen both sides in laboratory testing. So I am in the laboratory side of things, whereas Dr. Ukbo is a physician. He is a medical doctor. He has his MD, and he performs the actual autopsies.
And
So I
doctor,
know
just a
there
quick
was-
request. Can you
Yes.
speak a little loud, more
Oh.
directly into the microphone?
Yes. I will move it up.
They want to
Most of
hear
you
you.
hear what I just said? Am I going to have to do that again? So, when Lou reached out to me, I think it's really important. A lot of people don't understand the roles that individuals have within different sectors, especially of a medical examiner coroner's office. So I thought it was really important to be represented here. This is not our case. This was obviously in North Carolina. We represent Los Angeles County. So our policies and procedures are different. This was many, many years ago as well. So things have changed. But it's, for me, I would give the toxicology side of what was presented to me in the Netflix series. That's the toxicology testing. And it's very limited. There was alcohol in the system of Kathleen Peterson. It was at 0.07%, which in general terms is not a significant impairment for someone that has been known to drink. And based on case history, the Netflix series, of course, I don't have the full actual investigative report. It's based on what was presented to me. She had some form of alcohol tolerance just based on the fact that her and her husband, Michael, enjoyed wine together or drinking together. So that wasn't unusual. But the amount found in her system is not something that would lead to a huge impairment to where she would be completely unstable and fall down the stairs. She also had some drugs in her system. She had trace amounts of a antihistamine, which was chlorpheniramine, also a muscle relaxant, which is cyclobenzaprine. Trace amounts, they don't give actual concentration levels because They were very small amounts that she probably used on a regular basis and were just found in her blood. But there was also diazepam, which is Valium, and it was within a therapeutic range that was found in her system. I'm not going to get into the technical or scientific details of that. I know that's not what you're here for, but that is my perception on what was in her system was not something that would cause a impairment at a level to where she would be unstable or have any type of fall. Again, this is on the limited information I have as well. I don't have the full investigative report that was from law enforcement agencies or the actual medical examiner coroner's office at Raleigh-Durham.
So in your professional opinion, you cut out toxicology as a potential cause of death?
Yes.
Can I ask a question?
I would love that.
But I'm not going to cross-examine. Talk a little bit about the potentiating effect of the diazepam with the alcohol.
Yeah, anytime you have so alcohol is a depressant. Valium, diazepam is an anti-anxiety drug, so it's trying to bring you up. But there are cross-reactivities that occur, but for someone that is tolerant to a drug over a period of time, your body basically develops a new homeostasis, so it's a balance in your system. So I'm just basing this on the information that was provided to me.
I won't cross-examine you.
Yes. It's just not going to be a potentiating effect or level of impairment as someone that's completely naive to these type of drugs, if that makes sense, right? So it's like a foreign substance being introduced to your body. When you first take a drug, you're going to feel a very significant effect. You're hoping it's prescribed for a specific reason and you're going to receive that effect. But over time, that same dosage over time, you're not going to receive the same effect. So there is cross reactions that occurs with multiple drugs, but just with the information I've been given with the alcohol and the diazepam level at the level that it wasn't something that would have contributed to a impairment level of where you're out of balance or impairing in your vision, your balance, your speech, or anything of that.
So if you have a .07 level of blood alcohol, and then you have diazepam on board as well, where does that take you, in terms of the equivalency in alcohol? I mean, would it take you up to a 0.10? Would it take you to a 0.9? Give me some sense of...
That's very hard to determine because the number of drinks you intake doesn't necessarily mean intoxication for everyone at the same level, because we all are physiologically different, all right? And there's genetic components that come into play. You also, when you're determining estimations, body weight, body fat percentage, weight of that individual as well. So even though we have estimations that are out there, you can never truly state that at this level, with this amount of alcohol, you could get to a certain level because there are these variances that you cannot account for.
But, and again, I don't mean to cross it down.
I think you are.
I just hope Netflix is getting this.
Could we agree that the level of impairment would be something over .07? In other words, if Kathleen acted in a particular way when she had a blood alcohol content of .07, would you agree that adding the diazepam would increase whatever impact the alcohol had, or no?
I would never state that. I would never say that would, because there's variances that I cannot account for. It can happen based on the information that I know with this case and the fact that she and Michael enjoyed alcohol together. They drank, consistently together. Based on the level that was found in her system, of the Valium, the diazepam, I mean, it's a therapeutic level. And I would not consider, I could never say, yes, I would know it would go to impairing, a more significant impairing level because I can't account for certain variances within her system. I can just base it on what I do know.
Could be lower or it could be higher.
Absolutely.
Okay.
That is fantastic, ladies and gentlemen. Can we get a hand of applause? The idea of having two people on the panel going back and forth, we're not trying to cross-examine, we're not trying to make it adversarial, but it's sometimes through that Socratic Q&A method, which is where you get the best information. I was so happy that we got to hear that. But I got to keep time, and don't get me wrong, I'd love to let them speak forever. It looks like we're going to go a little bit late tonight. Is that okay with everyone? Yeah, I figured it would be. So we have another doctor on the panel, Dr. Ukbo. I can't see you. There you are. So let me ask you a question. What is your opinion on everything that's been discussed so far? If there's anything in particular that you really want to share with us, please go ahead.
So first, just a quick disclaimer. The opinions that I'm going to express today don't represent LA County. They're purely
He's a professional, ladies and
my
gentlemen.
own. So get that out of the way. And so what's fascinating about this case is I like to talk about what us medical examiners do. We're physicians. And our goal is to determine the cause of death in an individual. And then we're also tasked in a medical examiner system to determine the manner of death. So you have various kinds of manners of death, which include natural deaths, accidents, so much like a car accident, suicides, homicides, and also we have a category called undetermined. And undetermined, an example of that would be if, let's say, someone was found at the bottom of a cliff and they're dead. There are various sort of reasons that that person could have been at the bottom of the cliff. I think that many of you can think of a few of them. For example, if someone was intoxicated and they were just walking along and fell off the cliff, that's one possibility. But let's say that we heard that there was an argument happening prior to the person falling off the cliff. Could the person have been pushed? And then also, could the person have jumped intentionally? And so the autopsy is not actually going to be able to tell the difference between those three different scenarios. Rather, the manner of death would, if we don't have any information, it would be undetermined in that circumstance. And however, we rely a lot on a history. So what happens? So you go to your doctor's office and you say, well, I had this cough and now I have a fever, et cetera. And you start to work up the case. So we're getting the history of the individual. So the history of the case is very important and essential in determining the manner of death. And the autopsy, when the cause of death, which is the event that led to death, so like a gunshot wound or blunt head trauma, is something that we can determine rather easily. However, in a case such as this, blunt head trauma, this is one of the more challenging cases that we see as forensic pathologists. It's not as straightforward as a gunshot wound case where it's just like, well, range of fire, who done it? It's just the person died of a gunshot wound, and so we don't really determine the circumstances. But what's fascinating to me about this case is that it involves that challenging task of, you have a case of blunt head trauma, and you're supposed to, in a medical examiner system, determine the manner of death, and that often involves, actually every time involves the coroner investigator report, who goes out to the scene and gets the information that we need. And then photographs are taken at the scene. And so we review those things before we go down and do the autopsy. And so that's what sort of struck me about this case, that challenge that we see. And when I saw the autopsy report, I was like, oh, gunshot wound maybe? Oh, no, it's blunt head trauma. So it's a challenging case.
It's even more challenging than you say, because the cause of death was not blunt force trauma. The cause of death was actually exsanguination or loss of blood. Indeed, we found a note in the post-conviction files where Deborah Radish had told Freda Black, this is a Freda Black note, that she had originally determined the cause of death to be blood loss, and that John Butts, who was the chief medical examiner of North Carolina at the time, had insisted that she change that to blunt force trauma. I'm not sure why that was, but blunt force trauma was not the cause of death here. There was no brain injuries, there was no fractured skull, there were no subdurals, there were no bruises in the brain. The cause of death was loss of blood. So that complicates the whole picture, I think.
Doctor, if you have a response.
Yeah. I might have a little something there, but so one of the things that is challenging is to also understand how we determine the cause of death. So what does the cause of death mean? Cause of death really is the events that led up to the death, so the injury that caused everything to happen. And so there are several things that can happen to an individual between death and that event. So for example, if someone were to die in a car accident, if they get in a car accident and then they go to the hospital and they're there for a week, they may develop a pneumonia, infection in all the wounds that they had, all these sort of complications that result, blood loss and those various things. Those are called mechanisms of death, and they're not causes of death. So in that case, a car accident would be the cause of death is blunt trauma. As it is in this case, it would be inappropriate to just say exsanguination, because you have to say, how did that happen? Because you can have it from a stab wound, you can have it from a gunshot wound, you can have it from blunt head trauma, and so that's why that distinction was made in the end, because that's the more appropriate cause of death.
Do you mind if I just jump in here real quick, Doctor? Because piggybacking on what you just said, so we had, what, 7 lacerations and no skull fractures in this case. Is that consistent, in your professional opinion, with falling down stairs?
You're not speaking for the LA County coroner now.
Can I get an objection from someone?
Objection calls for expert testimony, vague and ambiguous, incomplete, hypothetical, so on and so forth.
So the cause of the lacerations here, I have to consider sort of called a pretest probability, and seeing the multiple amount of people that I've seen that have died from falling down the stairs. And so in my experience of seeing someone falling down the stairs, there are impact sites, and they could develop these abrasions, which are scrapes, contusions, which are bruises, and occasionally they can have a laceration. The injuries there are frequently subdural hemorrhage, which is bleeding under the thick layer that's covering the brain. When examining a case like this, I have to consider the multiplicity of the lacerations. And the multiplicity of the lacerations is not consistent with a fall, and so I have to consider other mechanisms that this injury had happened.
Like an owl, maybe? Yeah. Doctor, thank you so much. We're going to probably hear more from you once that owl comes out. Next, I'd like to introduce to you UCLA law professor Pavel Wansowitz. And when I heard that you were going to be on the panel, and I know that you did a case study on this particular case, I said, why this case? There are no shortage of murders, no shortage of cases. Why this case?
And before I answer, let me just kind of explore what everyone here is thinking. Oh God, a professor. Things had been going so well up till now. Is the bar open? You know, I appreciate that there's kind of this now, the ivory tower egghead is going to talk for a long time. So, but, and so, thank you for that laughter. So, the idea of what intrigued me about this case was, well, two things, essentially. I was trying to write an evidence textbook, and the idea is that an evidence professor is the first professor you throw under the bus. All you lawyers are nodding your head. I learned more in my first trial than I ever learned in evidence. And yeah, there's a problem with evidence professors because we can get a little ivory towery. And so I wanted to write a book that was based on the problem method. I wanted to write a book that teaches students how to make decisions under conditions of uncertainty. And so part of that was I did the problem method rather than law review articles, rather than a lot of cases, a lot and lots of problems. So let's look at great conditions of uncertainty and how do wise people maneuver in those situations. And while The Staircase has a lot of conditions of uncertainty, a couple things really kind of struck me about the documentary and, of course, the case. First, many pieces of evidence can ruin the tapestry of a case. You pull one piece, one thread out, and the tapestry changes dramatically. And those threads in The Staircase were often, my opinion, you may disagree, 50-50 coin flip propositions that were absolutely fascinating pedagogically. One coin flip, one decision that reasonable people, reasonable lawyers, reasonable viewers who don't have a law degree, reasonable judges could disagree on, that absolutely could, and I think did, affect the result. One example is, of course, Brad and the sex worker and the pornography that was found. Different result. If that was not let in my opinion, absolutely. And so sitting back and evaluating, okay, what's the probative value here? Okay, motive, maybe. Disrupts the idyllic nature of the marriage, could be if a couple of things line up. But wow, the unfair prejudice, especially, as I'll talk about in a second, the way that evidence was used and crafted by the prosecutor in the case. So that question of how do we weigh that probative value against that prejudice? There were options, I would imagine, to have scalpeled some of it off, but the judge let it all in. And I think that was a monumental decision in the case that really a lot of students could explore very deeply. The second, of course, is the death in Germany. Different result if not let in my opinion, yes. What we worry about when we let in so-called propensity evidence is that we're going to over-persuade the jury and lead to a preventative conviction. And while this evidence absolutely ran that risk, this idea that a jury could have been over-persuaded by hearing about what happened in Germany and thinking to themselves, well, I mean, he's obviously a stairway serial killer. I don't need to listen to this evidence because I got that. There's also that risk of a preventative conviction. My heavens, he was never punished for Germany? Well, we can fix that right now. And we're suddenly, the whole trial is now thinking about what's happening in Germany and trying to get the jury off that so that they're looking at it for the reason it was let in. Intent, knowledge of what such a scene could look like so it could be maybe replicated, absence of accident, doctrine of chances, which all seem to me like veiled propensity reasoning, that kind of once always once a stairway killer, always a stairway killer, which is not the purpose that the evidence should have been looked at. So those moments, those fascinating pull the thread and the entire tapestry changes, and the fact that they were close calls really kind of influenced me to start using not only the case materials, but the video clips. I have the exclusive rights. If any of you are thinking of writing an evidence book, don't do it. It's worse than a kidney stone. And so I started showing clips to illuminate, to start talking about what lawyers do in moments of uncertainty. What arguments should they be gravitating to? What facts should they be emphasizing and de-emphasizing in creating that tapestry? But the second reason I was really fond of the case from a egghead law professor kind of way was that if you start pulling some of these threads, it shows the limits of evidence law in a really profound way. So the goal of evidence law is to achieve the right result. And what was striking to me, to most of my students who watch it and who often schedule office hours after I show some clips to kind of debrief and want to talk about it, was how the method of proving propositions could often veer violently away from the arguments that led to their admission. And it really showed kind of the difference between knowing the law and lawyering, which are different things. It also really kind of pushes one's faith in jury instructions. Ladies and gentlemen of the jury, you may use this for X, but please don't use it for Y. Don't look at Y. I'm going to stop talking about Y. You can't use it for Y. And that to me was typified by Ms. Black's, the prosecutor's closing regarding Brad, the sex worker. And so I show that as a 4-part sequence. I take 4 different parts from the first 8 episodes. The first is a brainstorming session between Mr. Rudolph and Mr. Maher, where they were thinking about the argument to come and doing that kind of spitballing that lawyers do, which I think is incredibly valuable to future lawyers, to just kind of see 2 lawyers kind of say, let's keep bouncing things. Play devil's advocate. Bring it. That's great. That rarely has been captured before. And I was a trial attorney for a number of years. It's so much a part of all our days. I really appreciated seeing that. And that was the clip where Mr. Rudolph said that, contemplating sex with a prostitute really doesn't say anything about your marriage. I was watching that clip with my wife. And she said, "So help me God if you nod your head." The second clip I show is then the argument. 2 lawyers spitballing, playing devil's advocate, doing that Socratic method that you alluded to. And enter the argument. Okay, motive. Brad, the sex worker, shows us motive. The pornography in the computer shows us motive. And there's a big kind of conditional relevance problem here. If this evidence was discovered by the victim, if this evidence was previously not known to her and came as a surprise to her, if it would upend the marriage, then perhaps, yes, if we can kind of jump through all those hoops, then we got ourselves a motive. Likewise, the idea of rebutting the idyllic marriage, I get it. Those were the stated purposes that the judge seemed comfortable with and upon which he ruled, yes, you may use it for those 2 purposes, motive and idyllic marriage. Then I show the students, okay, the judge has ruled in his wisdom. Let's see how it plays out. Let's see that direct and cross. And that direct, where suddenly we're talking about anal sex. Where did that come from? A quote from the Anchorman movie, wow, that escalated quickly. Suddenly, we're having this moment where we're focused on motive, where we're focusing on perhaps this doesn't reflect the most idyllic of marriages, and we're talking about the sexual positions, and everything under the sun was what they were contemplating doing together. And I think the cross, and I'm not saying this because he's in the room, I thought it was a wonderful cross-examination, where the cross of Brad focused on How many of your clients are married? How many of your clients are professionals, including one judge? A moment that my students love. How many are bisexual? How many have wives? A really lovely job, I think, of limiting the probative value of why this was coming in. After that, are we really feeling motive here? Are we really feeling that we've destroyed the idyllic marriage and all the other evidence that showed a potential wonderful, close relationship? So students tend to think that's the end. Okay, judge ruled, one side presented evidence, the other side combated it. It's kind of a, let the weak evidence lose kind of situation. And then comes the clip of the closing. The closing, where Ms. Black referred to Michael Peterson as a bisexual. I use 4 syllables when I use bisexual. She uses 12. It was kind of a long word as I was watching the clip. Her allusion that, does it make sense to you that while she went to work, he stayed home and was looking for a sexual dalliance? So again, kind of playing with that stereotype of, the woman was the bread earner, the wage winner in the family, while Michael was at home looking for sex. I don't want to offend anyone, but this was anal sex, so that came home to roost. The way she talked about the pornography as any which way. I don't mean to offend you, she says, and she throws the pornography on the jury and says that is hardcore porn. And so we get these moments where and then she closes by saying, and that's not how soulmates react. So she brought it back to the probative purpose of it, but with a whole lot of prejudicial stereotypes thrown in. And so it was moments like that to me, again, that's a very long answer to a very good question, offer that rare view of both the micro and the macro. It teaches how the rules of evidence should be argued by capable, very zealous advocates. But it's also fascinating to look at how evidence can be used and misused. And the staircase provides very valuable insight for that as well.
That is incredibly interesting. Just out of curiosity for the lawyers in the audience, does anyone here miss law school? I do a little. Is that strange?
Yeah, not at all.
Okay. Well, guys, I just want to go ahead and say something real quick, and this is super important. So let me just walk over here. What I want to go ahead and do is we're going to break in just a minute. We're going to have an intermission. And by the way, I don't know if Mr. Rudolph realized this, but he plugged the owl. You know why we have the owl in the second hour? So you guys all come back. That's a whole idea here. But we also have a district attorney who I know has some opinions. So let me just talk about this panel for a second, and then we're going to break for our intermission. First, I got to tell you guys something. This panel was put together by Mr. Lou Shapiro. People tell me, Daniel, you work a lot. And my response is, have you met Lou? And I see the emails he's sending at 1 a.m. And, he really put this together. And it's a beautiful panel. Look, we got a criminal defense attorney. We got scientists. We got a professor. And we're going to have the offense coming up in just a second. So you get to see perspectives from all areas of the law. And the only way the WBA is available to do this at no cost is through the sponsorship. And this is why this is so important. This is why I came out here to say this to you guys. So we do something a little different. I think the State Bar requires us to have a 10-minute break. We have what we call a sponsored break. It's 20 minutes. We double the time. Here's why. You take your 10 minutes, freshen up, use a restroom, do what you got to do, all that stuff, and then you should have 10 minutes left over. At that point, from everyone on the WBA board, we sincerely ask that you go ahead and you patronize all the sponsors who are out there, because but for them, we wouldn't be able to do what we do. And by the way, it's not like we have lackluster sponsors out there. These people are all hand-selected, and we believe that they will provide you all wonderful, products. So why don't we break for 20 minutes, ladies and gentlemen, and we'll see you all back here in just a second.
So, some of you may have watched in The Staircase when Henry Lee testified. You know, Henry is, if he's not the world's foremost expert on crime scene reconstruction and interpretation, he's certainly in the top three. And so we're really fortunate tonight. Henry's in China, but he's agreed to appear, via satellite or via satellite?
We're going to FaceTime call him.
Henry! Why did you give Deaver that book?
I sent the book to the best attorney.
Why didn't you tell me you gave him the book?
My book. Did you read the whole thing? The Chinese book?
Yeah, well, we just showed the clip where you got cross-examined with your book, and I told them I had no idea, and then you said that I was a lousy attorney. I'll let you take over, Henry.
You're
Thank
the
you.
best. You're the best.
Okay, Dr. Lee, can you hear us very well?
Yes, I can hear you.
All right. I know you have some slides that we're going to show the audience. So let's talk about your testimony in the trial and talk about the forensic evidence.
The first slide shows one of the best attorney working. The best attorney just like a coach and a quarterback. Second slide shows the real worker. That's me. I have to take some blood out, put in my mouth, and try to reproduce so-called medium velocity blood spatter. Those blood stains found on the wall, it's not because beat up the decedent. Actually, because the decedent wasn't dying and lying there, suffer and coughing. The third slide is a distance view, shows the overall view of the staircase. The fourth slide is a close-up, show the major stand, which actually consists of 5 different types of blood stain. Some are contact transfer, like a hair swipe. Her head touched the surface. Then some are running pattern. That shows she already have some open wound, blood floating from the top down. We did not see any sign of a struggle. If it's a beating, we should see some pattern of struggle. In addition, we have blood spatter. The next slide, number 5, is a close-up, shows a portion of the blood stain, which the prosecution say this due to the beat up. Repetitively, her head was hit. However, when you examine those blood stains, probably about 500 of the individual blood stains. If you look at number 6, it's enlarged a little bit. You can see many of the stains without center, with a gold center, or sometimes people refer as a hollow stain, which means those blood stains initially have some air bubbles, hit the surface, subsequently dry, the air bubble bust, so leave a holy pattern. Next slide I point out some of those mixture of a different type of pattern of slide. You have a red arrow, that's a whole blood, which means the blood without dilution. You have a yellow color, those shows without the center. Also, the blue one is very diluted blood stain. That shows could be mixed with saliva. That's why the prosecution we suggest should test for amylase. Amylase is a digestive enzyme in person's mouths. So in other words, the source of the blood, it's not really from her wound on the head, on the skull, but it's come out of her mouth because the blood got into the mouth and start coughing out. Now we look at the next slide. That's an overall view of the staircase. Prosecution claim she was beat up in that area. That area, I'm sure David Rudolph already talked about, is a very small confined area. If you look at the following slide, shows the floorboard. That's the area they think her head was lying against the floorboard, and Mr. Peterson beat her up. However, if you look at the next slide, that indicates she was lying on the floorboard at one of the time. Cause that
He is coming through from China, ladies and gentlemen. Let's see if we can get him back on there. Are these photos tough for anyone to take a look at? I heard absolutely yes, and I heard absolutely no at the same time.
hello.
We're back.
Modern technology. Okay, next slide. The next one is a close-up. I illustrate those wholly center, no center blood stain, which again, because her coughing. So she probably lying there for quite a while. And the blood drip into the mouth and the nose, start coughing out, create those, which I think the prosecution expert completely overlooked, either intentionally or unintentionally. The next slide shows the overview from the top stair downwards. In addition, we shows her head injury. Now, if we look at this house, it's a very old house. The construction is an excellent woodwork. So the next slide shows the molding. It's not like a modern construction. It's just one corner. It's got multiple corners. So we can see that slide. I show 3 dark blue arrow, shows the 3 areas have a physical contact, which indicative at one point in time, her head have contact that molding area 3 separate times. So the following slide is a more close-up showing that so many days later, when we examine the surface, we still saw the hair adhere with the blood stain. That's another indication her head was bumped onto the molding, separate tab. Each tab bump in the molding, as you can see the next slide, and the molding area, the construction, so each hit may cause 3 or even more injury by single contact because the uneven surface. So the physical evidence actually shows us that's more likely it's an accident instead of a homicide. Okay. Very much.
Dr. Lee, one more question before we let you go. You've heard of the owl theory. Do you think that the injuries could have been caused by an owl?
I'm not very owl. So I cannot reproduce the experiment.
All right, thank you very much. One more time, Dr. Henry Lee joining us from China. Thank you so much.
Thank you, everybody. You're wonderful. Thank you.
Bye-bye. Thank you, sir.
Okay, ladies and gentlemen, we're going to go forward. We have 2 more presenters here, and we've definitely saved some of the best for last. We have a Deputy District Attorney, Miss Rena Durant, who is going to discuss her opinions of what's going on. Miss Durant.
Thank you. Can everyone hear me? Okay. So again, my opinions only, not the opinions of the Los Angeles County District Attorney's Office. I've been a deputy DA for 11 and a half years. I'm currently running one of the busiest courtrooms, I think, in the country. But before that, I spent a large part of my career prosecuting sex crimes, child abuse, and domestic violence cases, and working alongside victims. And I just want to take a poll of how many people in this room are trial attorneys who work with juries. Okay, a decent number. So for those of you who don't do that, and for those of you who aren't attorneys here, you may not realize that what we do as trial attorneys is we tell stories. And that's our bread and butter as trial attorneys, is telling stories. We also live in a city that is based on telling stories, and we're in Hollywood right now. So I think a lot of people we surround ourselves with make their bread and butter by telling stories. And why am I bringing this up? I'm supposed to be the DA just telling you and getting pissed off and telling you stuff. Because The Staircase to me is a story. It is not truth. And I think a lot of us want to watch these true crime shows because we want truth. If we just wanted a story, we'd go out and watch some crappy thing in the theater. But we're expecting truth. So what I would like to point out to you is some of the evidence that was left out of this documentary. They had $143,000 in credit card debt. Michael's 2 sons, his biological sons, had their own massive amounts of credit card debt that he was worried about. In fact, just before Kathleen died, he had messaged his wife, his former wife, the mother of his 2 sons, saying that he didn't know how he was going to pay for all this and that he couldn't even bring this up to Kathleen because their sons were in such bad debt. For 3 years before she died, they were spending $100,000 more per year than they were bringing in. Most importantly, she was married before, and the reason she left her first husband was because he was cheating on her. Okay? Think about that. So, Michael, we know a lot about Michael, and I would posit to you that he is one of the major storytellers that we hear from in this documentary. Michael, who claimed to have 2 Purple Hearts that he got during his service in the war, but it turned out he only had 1, and it was actually because he got into a car accident in Japan. Michael, who wrote a drunk driving column claiming to promote zero tolerance, yet he had just gotten a DUI a few years before that. Initially in the documentary, he's confronted with his bisexuality by his lawyer, by the private investigator, and I think his response is, "I would never do that." Well, then it comes out, no, everyone knew about my bisexuality, including my wife and all my children, except none of the kids actually knew. And every time he was asked, well, did Kathleen know? He could never give a direct answer. It was always something like, well, it was implied. He was interviewed in 2017, and I'm going to read this directly. Quote, "I never talked to a soul about it. It's like when you get away with something, you keep getting away with it. It becomes, oh, it's all right." That was in reference to his bisexuality. But this is who we're talking about here. This is our storyteller. He was this big writer. That's what he did for a living, is he told stories, but he was barely bringing any money in compared to Kathleen. He ran for mayor unsuccessfully. That's when we found out about him lying about his Purple Heart. And he also had a book deal ready with HarperCollins during the trial in the event that he was acquitted. Book deal never went through. Liz Ratliff, the German woman, when her husband had died, she was given a $250,000 life insurance policy, and Michael, being the good guy he was, decided that he was going to handle that for her. I personally don't have any information as to what happened when Liz Ratliff died and her inheritance, but it was convenient that he then took over responsibility for her two children. I'd also like to point out that he developed a romantic relationship with the editor of The Staircase that lasted until 2017. So let's get to that night. He claimed that she was still breathing when he found her at the bottom of the staircase. Well, paramedics said that when they arrived, she had been dead for quite some time. And how did they know this? They knew this because the blood was dry. The blood was too congealed for a fall that had just happened. And we later found out that there were red neurons present in the blood on her scalp. And you only see those when there's been 2 hours or more lack of oxygen to the brain. And if I'm getting that science wrong, you guys can correct me on that. Also, there was a cleanup. Under her body and under her head were paper towels, Michael's socks, Michael's shoes. If your wife is sitting there dying, breathing her last breath, what are you doing taking your shoes off and wiping things around? Luminol showed that there were footsteps leading from the scene of her death to the kitchen to the wine glass cabinet, and that there was a bloody fingerprint on that cabinet. Next to that cabinet were 2 wine glasses, neither of which had Kathleen's fingerprints on them. Why is this significant? Because if you want to make it look like an accidental fall, it's a better tell if you've got an empty bottle of wine and 2 glasses to signal that she had been wasted and drinking all night. But we know she wasn't intoxicated because she could have driven a car safely and been under the legal limit at that point. There are no injuries on her body that suggest a fall. She didn't have bruising that I'm aware of on her body. I bruise easily and I fall and I'm clumsy. And if I fall, I have bruises on me. We didn't see anything like that on her body. Furthermore, and I think this is probably the most significant piece of evidence that I cannot believe was not mentioned in the documentary, is that according to the coroner's report, there was a bloodied fracture with hemorrhage on the small extension off of the left thyroid cartilage. What does that mean? Bruising on her neck, okay? That is inconsistent with a fall. That is consistent with strangulation. And if we have time during the Q&A, I'd love to hear more about that from the doctors. So the owl theory, okay? Meanwhile, this is the only reason I agreed to be on this panel. But I think there's no coincidence that Liz Ratliff had 7 lacerations on her scalp when she died. Kathleen Peterson also had 7 lacerations on her scalp. That would have been 2 very similar owls who attacked these 2 women across an ocean from one another, if we're going to believe the owl theory. I'm just going to end by saying that the fact that we're all here and that people have such strong opinions about this show indicates that stories and the stories we tell are powerful. And with great power comes great responsibility. Because stories have consequences. The people who watch these shows are going to be the people sitting on your juries who are going to feel like they can't trust anything that they hear anymore. And we live in a world of Me Too. We live in a world of fake news. We live in a different world now where we have to question the information we're getting, who's telling us these stories, and what they have to gain by it. And if we're being told a story where we're hearing more about a man's sex life than we are about a woman's career and who she was, this woman whose life was taken too soon, it makes you wonder, is this the kind of story that I want to promote? So I urge you, not as lawyers, but as people, to take responsibility and have integrity in what you do and how you tell your stories. And search for truth and not just winning, because there are losers everywhere. Kathleen was a loser in this case, but she's somebody that the filmmakers all but forgot in how they portrayed this story. So, don't want to end on a dark note, but thank you for giving me a chance to fill that stuff in.
Wow.
How about we talk about the owl?
Please, please.
Okay, so let's talk about the owl. Who is with the owl right now? This is Crystal Chen. She is an owl expert. I met her earlier today, and we had a good talk about, first of all, tell me about the owl that you have in front of you, how much it weighs, and all that.
Okay. This is Ethel, that's her name. She's a Eurasian eagle owl, native to Europe and Asia. And she's about 5 pounds. She's about a year old, and she's full grown. This is one of the largest owls in the world, much bigger than the one that's being suspected.
What does she eat?
She eats mice. In the wild, they would eat rodent, and these particular owls, they would actually sometimes eat smaller owls or other birds. And but she gets about 5 dead mice a day.
Oh, great. Do we have a video that we can show about the owl theory, and then we can talk a little more about that theory after we watch this? I heard it described that the talons on these owls are like knives, like they've got 8 knives at the bottom of them.
They're extremely sharp and powerful.
How powerful? I mean, do you think that an owl could cause that much damage to a human's head?
I don't know. I've never had one of these owls grab at my head before, but they have grabbed my arm, and it does hurt. But I mean, that's a different surface, so I can't really say.
And David, if you could talk about the decision that, well, because it came to you so late that you couldn't do anything with it. Were you in closing arguments at that point?
I was preparing for closing argument, so the evidence was closed.
Anyone else on the panel would like to give their opinion about the owl theory?
Well, what I'd like to do is I have a slide, and I can go through the evidence that supports the owl theory. It's a bunch of circumstantial evidence. I don't have a video of that owl attacking Kathleen, but there are a number of circumstantial pieces that fit the theory. So I've got that slide. Can you put that up? Okay. He escaped. I think you want to go, yeah. Okay. So, what I've got up on the screen are some of the pieces of circumstantial evidence that could have been argued at a second trial if one had been had. Number one is there are barred owls that were living in the woods by the Peterson house. That's not a coincidence, that's a fact. Barred owls are aggressive and can be dangerous. That's not speculation, that's a fact. And indeed, the Audubon Society, if you read that particular article, has confirmed that. Barred owls have attacked people on numerous occasions. You don't have to take my word for it. Google or go to YouTube and punch in barred owls attacking humans, and you will have at least 25, probably more, 50 videos showing barred owls swooping down on the heads of human beings and attacking them. There were drops of blood on the outside walkway leading to the front door of the house. At the time, I had tunnel vision, and so I didn't ignore them. You know, obviously I want to know what caused that. And so I came up with my theory. You know, my theory was that Michael, with blood dripping, because he had put towels under Kathleen's head, had walked out with blood, which, by the way, was not dry at the time the EMTs got there. That was added to their reports months later. But facts are stubborn things. So there were these blood drops, and I thought, well, Michael must have walked out and was looking for the EMTs, and those drops came off his hands. There was a large smear of blood on the outside of the front door, again, as shown in police photos. My assumption was that Michael had put his hand up there when he was waiting for the EMTs. At least 2 of the wounds on Kathleen Peterson's scalp, the ones on the far right side, are in the shape of the talons of a barred owl, as shown on the autopsy photos. The tiny wounds on Kathleen's face, there were little prick marks, are completely consistent with the tip of an owl's beak. A feather was found on Kathleen's body in dried blood. I assumed that that came from some sort of a down pillow. I couldn't understand it. So I invented my explanation, that it must have come from a down pillow. A twig was found on the stairway. I invented my explanation. It must have come from the Christmas tree that had just been put up. There were numerous strands of Kathleen Peterson's head hair, which the roots indicated had been pulled out, not cut, found in dried blood on her hands. So, how did those strands of hair get pulled out of her head? She didn't do it. Could an owl have done it? Wrapped in her head? Absolutely. Kathleen's head injuries are not consistent with her having been beaten by a blunt object, and I didn't hear any theory of what caused the wounds. You know, is it a blow poke? Really? With no cast off? So, she was beaten. If she was beaten, she had no brain injury, she had no swelling, she had no subdural hematomas, and she had no skull fractures. How many cases of blunt force trauma have you prosecuted where there was none of that and no defensive fractures on her hands where she was trying to protect herself? Tell me, how many cases like that have you had?
Mr. Rudolph, all I've done is mention the evidence that was presented at trial that wasn't included in the
No, actually
documentary.
what you've done is misrepresented the evidence. And you still haven't answered my question. How many times have you seen blunt force trauma injuries with the head where you didn't have any of those injuries? Because I can tell you in North Carolina, there were 250 blunt force trauma autopsies done in the 10 years before, and there wasn't one. Not one.
I think that's probably a question better posed to the coroner, not to a
No,
DA.
I asked you because you prosecute these cases, so you see what the autopsies are, and you're the one who misrepresented the facts. So I'm asking you, can you give me an answer?
I have not tried any of those, but perhaps we could ask somebody who could give us some scientific, large enough variables so that you could actually find a pattern.
Yes, thanks for your evasiveness.
Okay. Let's try to keep this civil, ladies and gentlemen. I understand. Look, guys, we got to bear something in mind. At the end of the day, we're all here enjoying ourselves. Someone did pass away as a result of all of this. It's a serious topic, and I can see why both a prosecutor and a defense attorney would feel very passionately about it. And
No, I feel passionately about facts. I feel passionately about facts. And what we heard 10 minutes ago were a few accurate facts mixed in with many, many false facts. And that's not fair. Well, excuse me?
Did she have tunnel vision? Because you said tunnel vision. You weren't paying attention. You ignored some certain facts when you're at the crime scene about the owl theory.
Yes, so?
So as a defense attorney, how could you have tunnel vision and not see these different things that could be evidence in your case?
Because I'm a human being. Because I'm a human being. Because I'm a human being.
Do you think Michael's going to stand there and wait with his hand on the outside door while EMTs come and his wife is dying on the staircase?
And what's your explanation of how this?
I don't know. I'm just
Exactly.
I'm asking.
Okay. I'll give you. Well, how am I going to go line by line? I didn't actually. Let's just be clear. Well, why don't you get? If she can give me her list, I'll go through them one by one. Yeah. I need to remember what she said. Give me your list, and I'll go through them. Well, first of all, the wine glasses were all done by Dwayne Deaver. So if you want to rely on Dwayne Deaver's stuff, you be my guest. There was no bruising on the neck.
Let's hold off on additional questions. We're going to actually pass a mic around. Much better that way, no?
The prosecution never argued strangulation. Because guess what? There was no petechia. There were no bruises on the neck. There were no outward signs of strangulation. Period.
What does the coroners have to say about this?
Well, I'm happy to hear what they have to say about it.
Yeah, Mr. Rudolph, let's hear from the doctors.
One of the concerning findings in this case was the fracture of the thyroid cartilage. So what is the thyroid cartilage? That's your Adam's apple. So there's hemorrhage there, which is deep bruising that you don't see on the external aspect of the body. So that in fact is a bruise. It's just deep. So the fracture of the thyroid cartilage is something that we see in cases of a strangulation or some sort of chokehold is placed on the individual. They don't have to die from that. It just has to happen in a second. So it doesn't necessarily have to be the cause of death. And it's kind of hard to fall on your Adam's apple. I don't remember someone saying, I accidentally, yesterday I fell on my Adam's apple. And it was kind of, so, and the reason why is because the head's out front, and so the neck is protected. So that's very unusual finding that was in this case. In regards to the brain injury, there is actually a significant brain injury in this case. It's called subarachnoid hemorrhage. That is a severe injury that I see in severe blunt trauma cases, and that is actually can be a lethal injury in of itself. Earlier, there was mention of red neurons in the brain by the DA, and red neurons are something that when the brain has an injury and it's not effectively pumping blood and oxygen to the brain, the cells start to die. In order for cells to start to die, you have to be surviving. So if you die instantly, you're not going to see this. So those are some things that were brought up earlier. I just wanted to clarify. Also, the mention of the owl. I just met this owl, so I'm not in cahoots with Al. I think she's a cool gal, but anyway, the implement that was used here was described as sharp. So talons are sharp. Injuries that are sharp, they cause what are called incised wounds. An incised wound, you could think of like a surgeon's blade if they were to cut open to start the surgery. The wound is very thin. And it's not a laceration. Sharp instruments don't create lacerations. They create they create incised wounds, as I mentioned. So laceration is where you have separation of the skin, and underneath it, it's sort of irregular tissue bridging. So that characteristic there is indicative of blunt trauma and cannot have been done by something that is sharp. So if we were to believe that this instrument here is sharp, blunt trauma by definition is injury due to something that isn't sharp. And so just to clarify some of the discussion.
Doctor, on that, if an owl grabs you like that, and they are very strong, so not just the cut, but couldn't the grabbing, like she said, if you've ever had any kind of, bird on your arm, they are strong, and they squeeze. They don't just slice you, but could have been caused by that, where the owl grabs onto you?
So if I were to believe that the talons are actually sharp, they would still make a cut, even if it's a very strong sort of injury. Lacerations happen from impact. They're impact injuries where the impact is struck on the skin. The skin is not able to stay together because the force was so strong that it actually tears. And so a laceration is a tear. And so it makes it very unlikely that something sharp would have been able to create that kind of injury.
Very, very interesting, ladies and gentlemen. By the way, anyone notice that the good doctor said I'm not in cahoots with the owl?
Oh, okay, you got it. All right. I thought no one got it.
I told the panel I was going to make one who joke. Okay. Is exemplified by the questions that are coming out of the
Daniel,
panel.
can I say something?
Oh, by all means.
Yes. I just wanted to throw out another theory to the owl theory that is there. There are tools that are used to cause blunt force trauma that we cannot forget. The fact that they were on a open wooded area. If there were tools, I don't know from what I was given if there were tools found at the scene, but I do want people to remember that tools can be utilized to make lacerations, marks on an individual as well. We actually have a tool mark analysis lab where we've found screwdrivers, hammers, several different tools that we actually can compare those tools and those marks that are found on the skull to determine how someone may have been killed. So it's important. Another theory to this owl theory is that there is a garden tool that is very similar. I don't know what it's called. I don't know the name of it, but I think you guys have seen it, but it's very similar to what a talon may look like. It's not very sharp, but you can use force to make marks on the head of an individual. But you shouldn't forget that there are tools that can be used against someone as well.
Very, very interesting. Okay, guys, we are almost at 9:30, and we're going to push just a little bit longer. I know there's a lot of questions in the audience here, and we're going to try to do a little Q&A real quick before we end this. Give me a show of hands. Anyone have a question? Yes, sir. And please go ahead and give us your name and let us know who your question's for.
It's for Mr. Rudolph. My name is Afshan Hakim, and I'm not a criminal defense attorney. My question was, at the point where you obtained information that led to the mistrial, or I'm sorry, the reversal, and it seemed obvious and apparent that there was misconduct on the prosecution's part. Did you guys consider filing a civil lawsuit against the county to get some leverage against them in order to back off?
No, because my focus was on getting him a new trial, and frankly, my focus was on Dwayne Deaver, not on the prosecutors. So that was not sort of anything that I considered. The leverage that I used was filing two motions. One, a motion to keep out the bisexuality because it had all been found as a result of a computer search, which the Court of Appeals and the North Carolina Supreme Court had ruled was unconstitutional, but then said that the evidence was harmless. So that would have been one motion. That was one motion I filed. And the second motion I filed was a motion to reconsider the admission of the Germany evidence because the law in North Carolina had gotten more strict with regard to the admission of that kind of evidence. And so we filed both of those motions. We had a chambers conference. The judge indicated to the prosecutor that he should tell Candace and Lori that, because they were the holdup to trying to resolve this case, that the second trial was probably not going to be the same as the first trial. And it was at that point that they agreed to the plea. So the issue of prosecutorial misconduct or knowledge of what happened really never came up.
David, have you heard from the judge years, I'm back here, way in the back.
Okay.
Have you heard from the judge years later how he felt about allowing those two pieces of evidence in?
Well, you all heard from the judge at the end of the documentary. And like I said, the judge was a friend of mine. Still a friend of mine. I've never stopped talking with him. But, I thought it was really courageous of him to actually, on camera, admit that he had made a mistake. And indeed, he went further than that and admitted that he had, having listened to all the evidence, a reasonable doubt. And at the end of the day, that's what this case is about. You all can argue that he's guilty, you can argue he's innocent. The bottom line is, was there proof beyond a reasonable doubt when you take all the evidence into account? When you take into account, we heard about 650 hours and things left out. There was a lot of evidence that we liked that was left out. For example, there was no blood on the stairway in Germany. We had the Army CID officer who went to the scene, who had actually compiled a contemporaneous report, which we also had, which we introduced into evidence when he testified, that in fact the flashbacks that these women confabulated, because they were all put together in a motel room, in a motel area, for 6 days before they ever testified, didn't exist. There was no blood on the stairs. There was no blood on the walls. There was a small amount of blood underneath her head. By the way, also not in the staircase was the fact that Walter Reed Army Hospital had found that she had died of a brain aneurysm. And indeed, the German doctor at the scene had found the same thing. So, the bottom line is there's lots of stuff left out with 650 hours, and we can all be, really selective about what we're going to say and how we're going to pitch it. But the bottom line was the judge himself, having heard all the evidence, had a reasonable doubt. And that, I think, speaks volumes.
All right, we have a question in the back.
I've two questions, and they'll be quick. First of all, has anybody ever been killed by an owl before?
I have no idea. It's not a question of killing somebody by an owl. It's a question of, is somebody's scalp ripped apart? And by the way, when owls grab onto something like an animal, they don't just hit them and leave. The talons then are used to grab the skin and pick the animal up and bring it to the nest.
Sure, that's a prey animal.
Yeah,
exactly. I don't think the victim here was a prey animal. I think, if anything, it was maybe an aggressive attack by a wild animal. I don't think the owl had it in mind to take her home with it.
Well, that assumes a certain level of thinking by the owl, which we won't debate.
Well, maybe the owl was really hungry. But that's sort of my secondary to my main question here. There was, if I understand it correctly, I apologize, I haven't watched the show. But
I'm not sure you ought to be really asking questions if you haven't watched it, but I'll have to listen.
I skimmed it. But there's a lot of the original theory was that she fell down the stairs, and the evidence pointed to her falling down the stairs and hurting herself and bleeding out on the stairs. And then the new theory about the owl is that the owl got her outdoors, and then she bled out inside. But wouldn't the owl have had to attack her at the top of the stairs so that she could then fall down the stairs for...
Watch the documentary. There was never any suggestion by anybody that she fell down the entire set of stairs. Ever.
But the owl would have attacked her indoors or outdoors?
Outdoors.
Okay.
Okay.
And let's, sir, if we could, just because there's a lot of other people and we are almost out of time. Madam, I'm going to pass over the microphone.
Hi. So I had a question for the medical examiner coroner. So when you're referring to the difference between a laceration and like an incision wound, is it possible, did you look at her particular, the reflection of like how the wounds were reflected on that report? And I guess my question is it possible with the owl theory that with lack of an explanation from a coroner's perspective of how she would have sort of incision wounds rather than blunt force trauma, would it be reflected in the report just for lack, a human way of not understanding how, just like he was saying, I don't understand how there was feathers. Just you're filling in the gaps because you don't know how to reflect it.
So the difference between, is this on? Okay. So the difference between the incised wounds and laceration is by calling it a laceration, you're automatically saying it's not a sharp instrument. And looking at the wounds, you see that there's injury, and then underneath it, the tissue is kind of ragged underneath it. And so if it is possible that there could be a component of a laceration, but you would also see the incised wound sort of, which is a very sharp appearance of the wound. And I was not able to appreciate that. And the fact that the report is really just their opinion of what they thought it was. It's their notes. And so by calling it a laceration, I say that, well, then this can't be something sharp. But also the photo that I did see of the injury, I could see that there wasn't any element of that looked sharp to me.
Lena, I think we have time for one more question. You want to select someone out of the audience?
All right. Hello, my name is also Lena. So cheers to you. The question I have for you is for the DA. And my question for you is, could you tell us your sources, or is that protected information?
Oh, God, no. So there are plenty of sources that the BBC, they did, I think it's like an 18-series podcast, which might have been just as long as the staircase itself, where they consulted, and I listened to all of it, and I tried to be selective in only including things that were portrayed as pieces of evidence that were introduced at trial. So I didn't want to go into people's harebrained theories about things. I really just wanted to focus on, look, if you had been in that jury and sitting at that trial, what would you have heard that didn't make its way into the documentary? Because that's what the story is. It's not just what do you include, it's what don't you include. So that's where I got most of my information, and then reading a few other articles online. But did I have access to all the transcripts from the longest trial in North Carolina history, and did I read through all those? No, I did not.
And by the way, if we're going to talk about motivation, the motivations of the BBC people were to come in and undermine the documentary. And there is much in the BBC documentary, as there is much in Aphrodite Jones's book and various other books that have no relation to reality whatsoever.
Even if everything she said is true, it's still no proof.
Different question. But.
All right. Ladies and gentlemen, we have a time constraint. Okay, last question. Please, very quick. And who's it to? Okay, please, real quick, guys.
So you're very passionate that the prosecution was, you could have sued them, but you just didn't want to spend the time to do that. Why didn't you just turn them into the Bar Association?
No, I didn't say that. No, I just said that I never focused on that. I never thought about that. And frankly, prosecutors have immunities, as we all know. Whether they should have immunities or not is a whole separate question. But no, that wasn't my goal. My goal was not to sue the prosecutors. No, I didn't say that. Somebody else said that. All I said was, I had no quarrel with. Well,
withdrawing the question.
Yeah, I never said that I thought the prosecutors did anything wrong. I may have thought it, but I didn't say it.
All right, all right. Wow. 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 Okay, okay. What an evening, ladies and gentlemen. WBA, MCLE. Please, a round of applause for the panel. And also, a round of applause for the WBA board. Andrew, Eliza, Steve, are you guys here in the audience? Please stand up. Eliza, right there. Andrew, are you here? Steve, are you here? Okay, well, there's Steve right there, ladies and gentlemen. WBA board, we put a lot of effort into this, and we appreciate your patronage. FYI, some of the sponsors have raffles. They have booze and other cool things, so you probably want to go out there and see if you won. Otherwise, ladies and gentlemen, please make sure you checked in at the MCLE check-in sheet. Daniel Fruzen, founder of the West Side Bar Association, thank you for being here tonight.